appeal in the matter of the King on the application of SB by his litigation friend Roxanne, Nanton, and the Refugee Council and the Borough of Kensington and Chelsea.
Yes, good morning. Before you start, can I just mention a couple of things, please? The first is, please could you tell us both how you'd like to be addressed? Because people always, some people like Miss, but whatever, and it would just be helpful for me to know. So,
I tend to go for Miss.
Miss, okay, Miss Rowlands, and
I go for Ms as well.
Sorry,
Ms.
was that Miss or Ms?
Ms.
Ms. So did you say Miss?
Yes, I did say Miss.
You said Miss. This is why I asked.
I answer to most things, though, including "Are you?"
So that's, and can I just check? So that's Ms. Lou.
Yes.
Yeah. Right. Lovely. Okay. That's fantastic. Thank you. The second point is this: we've read the papers quite carefully, so you don't need to, as it were, read long passages out to us, because we have had the opportunity to do quite a lot of reading beforehand. But in the course of that, a point has occurred to us, which is whether or not this appeal is academic. And if the appeal is academic, then we would be bound to dismiss it without more ado. So we're obviously not going to do that now, because you're here and you've prepared for the hearing. But one of the issues we will have to consider in our judgments is whether or not the appeal is academic, and if it is, whether we should exercise our discretion nevertheless to decide it. So if you could, in the course of your submissions, address those points,
Indeed,
please,
my lady,
that would be we'd find that very helpful. Good. Well, I didn't think there's anything else you want to say again.
I apologise for standing up, but my lady would have picked up in our skeleton argument. That's our primary position, that the
Yes. Yes.
appeal is academic.
Yeah.
It's a bit unfortunate that when we filed it, it didn't get looked at until today.
But I think it's probably not a question we could have
No,
decided
of course.
peremptorily anyway.
But we had discussed this issue and
Yes.
wondered whether or not the court would like to hear the issue on academic before hearing the substantive appeal, so that if your view is that the case is academic, then we don't need to trouble the court further. We could develop the full argument on the issue.
Yes.
I leave it to in the court's hand on that.
Yes. I'll just consult my colleague. Well, as you see, we've had a brief word. We think it's better for us to hear the whole thing now that you're all here and you've prepared for the hearing. I can't remember, did the claimant below put in a document resisting the application for permission to appeal?
Yes.
Was that point taken in that document?
It was.
Point was taken.
It was, and
then
permission was nevertheless granted.
Yes, and then the respondent's notice also flagged that as
Yeah.
primary position.
All right, so it was flagged at the permission stage and permission was granted nevertheless.
Yes.
Yeah, okay, that's helpful.
Well, although we would... so I do apologise because my learner junior was the representative below.
Yeah.
But I understand that at the point in which my learner son put in the appeal, he hadn't been assessed completely yet, and the issue as to his age dispute hadn't been resolved yet with Southampton, so there wasn't, it hadn't become academic because he hadn't had a resolution of the age dispute.
If I can assist.
Yeah.
The court emailed us. The respondent solicitors raised this issue with the court and with ourselves.
Yeah.
They didn't at that stage have a copy of the Southampton age assessment. And we needed to see that before making a decision. Having seen it, we still were of the view that we wished to proceed with the appeal. We put in a response to the court, and it was after that that permission was granted. So permission was granted in the knowledge that there had been that change of circumstances.
Right. All right. Is there anything you'd like to add to that account of
I simply would
events?
say that the issue of whether or not it was academic wasn't flagged squarely in the appellant's skeleton argument. So the issue as to the Salem test, why this appeal nevertheless should be heard because of good reasons in the public interest, that issue isn't actually addressed by my learned friend in the skeleton argument. I don't wish to take a strict pleading point, but it's just the extent to which it was actually highlighted to the court is in a paragraph at the end of the skeleton argument to say, well, it makes a difference to the local authority. That's the extent of this omission. But we are where we are here, and the court is going to be hearing submissions, and I can deal with those issues in due course.
Okay, all right, that's very helpful. Thank you both very much. Yes, Miss Rowlands.
My lady, before we get into the substantive matters, there are a couple of housekeeping points. The first is that the case still appears to be listed as SB by his litigation friend Roxanne Nanton.
Yeah.
He is now, of course, an adult on anybody's case, and he does not now have the benefit of a litigation friend.
Right.
The next question, of course, is anonymity and whether we should continue to refer to him as SB.
Yeah.
Obviously, having regard to the fact that this case is being live streamed. Anonymity was continued by Lady Justice Andrews when she granted permission. The local authority has no objection to that.
And was he at that stage an adult?
At that stage, he was, yes.
But I think we should nevertheless be asking ourselves whether what the justification for that is if he's now an adult. Do you have instructions on that, Miss Lou?
My lady, Lady Justice Andrews' reason is at page 41 of the court.
Right, let's have a look at that.
And you see at the anonymity maintained, although on his case SB will have turned 18 by now, the underlying claim is a protection claim. So he is still an asylum seeker.
Oh, I see. So he's still making a protection claim. Okay, all right. Yeah, all right. In that case, we'll continue the anonymity order. Thank you.
And then in terms of bundles, my lady, you will have had, I think yesterday, some further copies of the bundles with my updated skeleton, my learned friend's skeleton, and the speaking note from Ms. Patton from the hearing below.
Yes, I think we eventually got either the bundles or their significant contents.
And I hope you've also had bundles of authorities.
Yes.
You say bundles plural. I've got one.
Yes.
Yes.
We've each got a bundle.
That's bundles for the team.
Yes, each of us has a bundle of authority.
Clarity is important, and that I think is what this case is about. I will, without further ado, make good that submission. My lady, my lord, this is a case about age assessment. Age assessment is not something that is susceptible to easy definition and putting within easy parameters. It's very much a sliding scale. This is something that occurred to me quite strongly yesterday when I went to Waitrose to buy a bottle of whiskey. And I went to the till and wasn't able to complete the purchase until the sales assistant came up and pressed the button saying clearly over 25. She carried out an age assessment of me that involved nothing further than having a look at my face, appearance. Sometimes an assessment on the basis of appearance and demeanour is as simple as that. Obviously, at the other end of the scale, there are cases where it is obvious that someone is a child, and there are cases that fall in the grey area in between. Either end of the scale, it's clear what happens. You either say, yes, you're an adult, go away, yes, you're a child, come in. Because it's all about come in, that is the question. Is this somebody who is in need of children's services? And the statute that we're working here is the Children Act 1989. Is this someone who appears to be in need of children's services? And of course, children's services, again, are not a one-size-fits-all thing. A 17-year-old boy doesn't necessarily need the same as the next 17-year-old boy. Social workers are charged with making an assessment of needs as well as an assessment of age in the appropriate case. A 25-year-old man won't need the same thing as a 17-year-old boy, more likely to need things like getting a job, settling down, starting a family, whereas a 17-year-old boy is more likely to need education, support with the changes that his body's going through, things like that. And that is why assessment is important. It is something that has become very much judicialised over the years, despite the hopes of Lady Hale in Avon Croydon. My lady, in that case, she emphasised, of course, that this is a children case. It's a Children Act issue. And she also emphasised that it is a case of judicial review. And it is important that that is the starting point for any challenge to the decision of social workers. At tab 5, page 97 in the bundle of authorities, you have the decision of the Supreme Court in Avon Croydon. And at paragraph 3 on page 2561 of the internal numbering and page 101 of the bundle, Baroness Hale of Richmond explains to us the importance of determining age. The importance, she says at paragraph 4, comes from two directions. If a young person is a child and otherwise meets the qualifying criteria, i.e. that they appear to be a child in need, essentially, they must be provided with accommodation and maintenance and a wider range of services than other forms of housing and benefit provision. And many people now recognise that a quasi-parental service for children in need brings distinct advantages over the housing and welfare benefits available to home claimants and the National Asylum Support Service support available to asylum seekers, as in the cases before us. My ladies, my lord, that was of course 2009. In the 14 years since then, NASA ceased to exist, but the provision of support to asylum seekers remains pretty much on the same footing, although of course it's something that is very much a political issue at the moment. At paragraph 5, she points out that the Home Secretary also adopts different policies in relation to asylum seekers under 18. Legally, these may not be relevant to the issue which we have to determine, and in practice they are much more susceptible to change than is primary legislation such as the Children Act, but they're an important part of the factual background. Again, since 2009 there have been developments, but the point that I make arising out of the difference between the Home Secretary's approach and a local authority's approach is that they're coming from two different directions. The first direction being the Home Secretary being concerned not to detain, not to detain as an adult a child or someone who might be a child. The margin of error that the Home Secretary applies is to ensure that no child is accommodated as is detained as an adult when they should be accommodated as a child. So when the person arrives at the port, at paragraph 6, immigration officers make a preliminary determination based upon his physical appearance and demeanour. In a borderline case, the policy is to give him the benefit of the doubt and treat him as a child. Going back to my point about there being a continuum of from the very obvious child to the very obvious adult, these are people who fall within the broader range of the grey area. They're then passed over to the local authority to make a closer focus determination. So the Secretary of State gives a margin of error in the first place that makes sure that nobody gets detained as an adult. In the middle bit, local authorities have to carry out an assessment, and it's to be carried out in accordance with the procedural guidance given by Mr Justice Stanley Burnton in the well-known case of B and Merton London Borough Council. From that case, of course, we get the term Merton compliant. What I want to make clear at this point is that there's a difference between the use made of that word in various contexts. Merton compliant in my submission means an assessment which is fair in the circumstances which arise and to meet that particular case, and it's a fluid definition. Other people use it as a Merton compliant assessment means an interview over a period of days with an an appropriate adult, with an interpreter if one is required, with a Mind at Two session, and with full research into the age of the disputed young person. And so I think there is sometimes some confusion between those two uses of that phrase. But to make it clear, when I say Merton compliant, I mean it's compliant with fairness for those circumstances. This is a topic that I will come back to when we look at the case of HAM and Brent, which I think puts it much better than I will be able to. So,
sorry to interrupt, Mr. Rose. May I just ask a question? Does Mr. did Mr. Justice Stanley Burnton, as he then was, make that distinction in his judgment in the Merton case, or is this an interpretation that you're putting on it?
In my submission, he does make that distinction,
Right.
and that was then taken up by Justice Thornton in AB in Kent, and then very much in Justice Swift in HAM and Brent.
All right.
So I will show you that in a moment, if I may.
Okay, that's very helpful. Sorry, I probably asked the question too soon.
It's always nice to know which way the court is thinking, so I can answer questions as we go along. So I'm very pleased to be interrupted. Let's move on in A and Croydon before we go to B and Merton to look at paragraph 32. Sorry, that's at page 108 of the bundle, 2568 of the internal pagination.
Speaking for myself, I haven't got a fully paginated authorities bundle. It's got tabs, which is all I need.
Has it got page numbers at the top?
Yes, it's got the internal page.
yes.
It's got the internal page. Oh, it has.
Oh, right. So I'm so sorry. I was
Should say
looking in the
page
wrong.
108 of 288.
I was looking in the wrong place.
In rather small typescript at the top. Yes.
So I was looking at the bottom.
Because I thought it would be more
More prominent.
It doesn't get involved in the pagination.
No. You're quite right. Okay. Well, that's very helpful. Thank you.
So paragraph 32, and we're still in Lady Hale. The Act draws a distinction between a child and a child in need, and does so in terms which suggest they're two different kinds of questions. But a social worker who is dealing with a person who comes to them and says, I am a child and I'm a child in need, is doing both these jobs simultaneously, because if you're not a child, you're not a child in need, but your childhood doesn't determine your needs. The word, excuse me, the word child is defined in wholly objective terms and defines the outer boundaries of the jurisdiction of both courts and local authorities. Under the 1989 Act, this is an Act for and about children. She goes on to say the final arguments raised against such a conclusion of a practical kind, and this is the practical effects that we're concerned with.
But the last sentence of that paragraph is quite important, isn't it?
Jurisdictional fact, yes. It's how old you are is a fact, but it's not a fact that you can identify easily. It's not something you can look up in an encyclopedia like the capital of France.
Sure.
And so it's something that we may never actually know, even after a fully contested hearing. You've still got some doubt as to whether you've got the right date of birth.
Yes, but if the court's decided it, then the court's decided it.
Then the court decided it. But sometimes you get cases where somebody comes up afterwards and says, well, actually, I fooled you all along. I was actually an adult. Or the other way around, you said I was an adult. I've now got my Tuskegee over from Afghanistan, look, it says I'm a child, local authority use their decision. Could go either way, of course, but
I mean, just to state the obvious, the question is, have 18 years elapsed since your date of birth? That is it.
yes, and the question, you can assess an age without necessarily assigning a date of birth.
Of course. But
But
the nature of the test is, as I've just said, isn't it not? I mean,
Yes.
that is the definition, presumably, of child or minor or whatever similar term one uses.
And of course, on your 18th birthday, you don't flip a switch and suddenly become an adult in kind of behaviour and demeanour terms. Everyone develops, and everyone develops at a different rate. So at paragraph 33, Lady Hale emphasises that this is a practical issue. The only remedy available of the decision of the local authority, the decision of the social workers, is judicial review, not well suited to the determination of disputed questions of fact. That the remedy is judicial review doesn't dictate the issue for the court to decide or the way in which it should do so. Clearly, the public authority, whether the Children's Services Authority or the UK Border Agency, has to make its own determination in the first instance, and it is only if this remains disputed that the court may have to intervene. The better the quality of the initial decision making, the less likely it is that the court will take any different decision on the evidence. And if the other members of the court agree with my approach, it doesn't mean that all the other judgments involved in the decision whether or not to provide services to children or to other client groups must be subject to determination by the courts, whether they're in need and how to meet those needs remain governed by conventional principles. At paragraph 43, 2571 of the internal numbering, the role of social workers was considered, and it was submitted that they can't be impartial because their authority has a direct financial interest in the outcome. Although their individual professionalism, he said, was not in doubt, they may unconsciously be influenced by tacit pressures from their seniors, who are only too conscious of the many demands on the children's services' scarce resources. Paragraph 44, the most reluctant to accept that Article 6 requires the judicialisation of claims to welfare services of this kind. Mr. Howell's argument cannot sensibly distinguish between the determination of age and the determination of the other criteria of entitlement. Every decision about the provision of welfare services has resource implications. Public authorities exist to serve the public. They do so by raising and spending public money. If the officers making the decisions cannot be regarded as impartial and the problems cannot be cured by the ordinary processes of judicial review, then tribunals will have to be set up to determine the merits of claims to children's services, adult social services, education services, and many more. Resources which might be spent on the services themselves will be diverted to the decision-making process. Such a conclusion would be difficult, if not impossible, to reconcile with the decision of the House in Room of Bagan, case on homelessness appeals. And she later said that at paragraph 54, I beg your pardon, we're into Lord Hogarth Head now. At paragraph 54 on page 2574. As for the practical consequences.
Sorry, perhaps you draw attention to paragraph 46, in which she says that if live issues remain about the age of a person, the court will have to determine where the truth lies on the evidence available.
Yes.
I can't remember, did the other members of the court agree with her?
Yes.
Right.
And that's why we now have the process whereby the first decision is taken by a social worker on behalf of the local authority. That is then subject to judicial review, and in the vast majority of cases it's now passed over to the tribunal to make a determination on the facts. This is subject to a very recent development, which is the introduction on the 1st of March of this year of the National Age Assessment Board, which has provided for a new team to do assessments on behalf of the Secretary of State. and that has its own appeal process. I haven't got myself any practical experience of that as yet.
Is there a statutory underpinning for that?
That's right.
Can you just tell us what the provisions are, please?
I beg your pardon, my lady.
Could you tell us what those provisions are, please?
Yes.
I mean, they're obviously not relevant in this case, but just out of interest, it would be, if it's not too difficult for you to tell us now, that would be helpful. But don't worry if it is, because you could tell us later.
The
It looks as though Miss Lou knows the answer.
I believe it's part 5 of the Nationality Borders Act 2020. It's part 5 of part 6. I can't remember exactly, but there's a statutory framework there for
Right.
assessing age. And you'll recall there's a lot of discussion in the media about whether or not you can use scientific methods. But as your leadership says, it doesn't arise in this case.
No. No, it's just
that's the
useful
framework.
useful
Yes,
background knowledge.
That's the framework.
That's very helpful. Thank you very much.
Part 4 of the Nationality and Borders Act 2022, Section 49 defines an age disputed person as an individual who requires leave to enter or remain in the UK, and in relation to whom a local authority or the Home Office has insufficient evidence of their age. Designated person means an official of the Home Office who is designated by the Home Office to
Well,
conduct
don't.
age assessments.
You don't need to read it out, I suppose. We can look at it after the
Section
hearing.
50 and 51.
50 and 51. That's really helpful. Thank you very much.
It's an interesting fact as well that the NAAB social workers, one of the social workers unions, refused to have anything to do with it because they didn't think it was as good as the systems that we currently have. So the Home Office has promulgated a new version of its guidance assessing age, version 6 now, that was 31st of March, but also the ADCS has promulgated an updated version of its guidance. You've got the working together guidance in the bundle, but there's an updated version of that, again from March 2023, the joint working guidance.
And for those who don't recognise the acronym, I think that's the Association of Directors of Social Services.
Children's Services.
Children's Services. Sorry, I misheard. I thought you said SS. Children's Services. Lovely. That's very helpful. So that guidance, what is its legal status? Is it just a document that's put out?
It's advisory. It's not binding on anybody.
No. All right. That's helpful.
This is an area where the only guidance that social workers really get that's in any way binding on them is from the courts, but the courts look at the guidance from the Home Office, from ADCS, and from the way that working groups have just worked together to try and develop a good way of doing age assessments. It's not an easy task when you're in that grey area in the middle.
No. Well, I was just interested in the legal status of any of this guidance, and you've told us what that is. Thank you.
Going back to A. and Croydon at paragraph 54, if I may.
Now, none of the other members of the court agreed with Lord Hope's judgment, so this is just out of interest.
I don't take any of them as disagreeing with what is said in 54.
Well, they all say that they agree with the judgment of Lady Hale.
They do.
They don't say they agree with the judgment of Lord Hope. Lord Walker refers at the end of his short judgment to one particular point, and he says, "I'd prefer to leave the point open while acknowledging the force of Lord Hope's reasoning." So the reasoning of the court is Lady Hale's judgment, is it not?
But both sides of the court, if you like, agree that the process starts with the decision of a social worker.
Yeah.
And the better the decision, the less likely it will be for the court to need to intervene.
Yeah.
So it's all about the weight here to be given to the decision of a social worker, which is it's judicial review. We are in the context of judicial review of that decision. The decision being entrusted to social workers in the first instance because it's their professional judgment they are trained not only in dealing with children, generally speaking, and experienced in dealing with children over a wide range of ages, races and social classes, and they are also given training in age assessments and how to carry them out, and are extremely concerned as to the fairness of the procedure that they are involved in. My lady, you asked about B and Merton, so can we go there next? And that's tab 1. I've highlighted paragraphs 20 to 22 on page 7. And at paragraph 22, Mr. Justice Stanley Burton noted the guidelines published by the Royal College of Paediatricians. Age determination is extremely difficult to do with certainty. For young people aged 15 to 18, it's even less possible to be certain about age. There may be difficulties in determining whether a young person who might be as old as 23 could in fact be under the age of 18. Age determination is an inexact science, and the margin of error can sometimes be as much as 5 years either side. So someone you think is 23 might be as young as 18. Someone you think is 23 might be as old as 28. The older you get, the bigger the margin of error. You take a 5-year-old, you're not going to think that they're 10. Or 5 years younger the other way, you're not going to think they're a baby in arms. The older you get, the younger they are, the easier it is. The older they get, the bigger the margin of error gets. By the time we get to 50 or so, you could be 70 or you could be 30. It's really hard to tell how old an older person is. Fortunately, not a job that we have to be concerned about. But one point I would also make is that the earlier a social worker can see the young person, the easier it's going to be to make an assessment of age. The margin of error gets bigger as you go along, and that's why it's this key area, 5 years either side, that is the grey area that has been determined to exist in subsequent case law. Mr. Justice Stanley Burton, of course, notes at 21 that there's no statutory procedure or guidance issued to local authorities, and that at paragraph 23, different people living in the same country mature physically and psychologically at different rates. There's no key marker that you can use. When the Cricket World Cup was in this country a few years ago, lots of Afghan refugees and asylum seekers were given free tickets to the World Cup, and they got very excited about this because Afghanistan were doing really well. And one submission that was made was, he was really excited about the cricket, so he must be a child. To which I said, well, you should have seen me when the final was ongoing. You would have thought I was 3 years old by the way I was performing. But it is difficult for a layman to determine the age of someone born in this country with any accuracy. A general practitioner is unlikely to have the knowledge or experience to improve on the accuracy of an intelligent layman. To obtain any reliable medical opinion, one has to go to one of the few paediatricians who are experienced in this area. Even they can be of limited help. In this case, there were two experts who were called. They've since been discredited because the use that a paediatrician can bring to a table is very limited as well. At paragraph 27, and my lady, I think this is the answer to your earlier question. There may be
yes, I've just read paragraph 27. Thank you, that's helpful.
And the possibility of obvious cases means it's not possible to prescribe the level or manner of inquiry so as to sensibly cover all cases. And I think it arises really out of general judicial review principles. What fairness demands is not a one-size-fits-all in any case.
Well, that's the famous dictum of Lord Mustell in Doody, isn't it?
Yes. And then he goes on at 28 to give that age range of, say, 16 to 20, where you have to do what has now been referred to as the full Merton compliant exercise. An applicant who may be in the age range of 16 to 20, it's necessary to take a history from him or her, usually him, with a view to determining whether it's true. History that's accepted as true and consistent with an age below 18 will enable the decision maker in such a case to decide that the applicant is a child. Conversely, however, an untrue history, whilst relevant, is not necessarily indicative of a lie as to the age of an applicant. And I think, again, this is a principle that permeates most areas of law. Lies about one point don't show that you're lying about everything, and they may be told for reasons particularly in relation to their asylum claim. Physical appearance and behaviour cannot be isolated from the question of the veracity of the applicant. Appearance, behaviour and the credibility of his account are all matters that reflect on each other. It's taking a holistic view of the person who claims to be a child and seeing whether everything adds up together. Someone who says, I've got a birth certificate that shows I'm 13, but who clearly looks to be 30, will not be credible, and that will then undermine other aspects of their credibility. But it's their appearance in those circumstances that may be the determining factor. And again, at paragraph 29, we have the advantages of being thought to be a child, and it is important to be mindful of the coaching that the asylum seeker may have had prior to arrival in how to behave and what to say.
And then the passage above, which says it's further complicated by many of the young people attempting to portray a different age from their true age.
Because they know of the advantages of being thought to be a child. The twofold advantage was in the asylum system, where they get more favourable treatment, and in getting the better accommodation and usually a higher degree of financial support from...
I think the position used to be, I'm not sure whether this is still the case, that people who are assessed to be children get leave to remain until they're 18. Is that right?
Yeah. I think these days you will then find it's a 5-year, generally speaking, a 5-year leave to remain. And Miss Lou may know more than me on that one.
If they're found to be a refugee.
If they're found to need
it's 17. They get granted until 17 and a half if their asylum claim is refused, but they get leave as a child. And then they have a right of appeal in any event in relation to asylum whilst they have to leave until 17 and a half. If they are granted refugee status, they get 5
Sure,
years.
that's a different issue. So the initial period of leave is until they're 17 and a half. And if the claim is refused, that gives them an opportunity to appeal before they're 18.
No, they get refused refugee status at the same time as a grant of the 17 and a half leave.
Yes, that's what I'd understood.
They don't like make an application for asylum and automatically get granted leave until they're 17 and a half. Everything is considered in the round together, and that's sort of an alternative basis of leave if their refugee status is refused.
Right.
If their refugee status is granted outright, then they just get the 5 years, and then they get indefinite leave.
Okay. Thank you.
Moving on to 3637. I think this is where events have proved Mr. Justice Stanley Burton wrong. The assessment of age in borderline cases is a difficult matter, certainly, but it is not complex, he says. It is not an issue which requires anything approaching a trial, but we do get trials on a regular basis now. Judicialisation of the process is, in my judgment, to be avoided. It is a matter which may be determined informally, provided safeguards of minimum standards of inquiry and fairness are adhered to. Except in clear cases, the decision maker cannot determine age solely on the basis of the appearance of the applicant. In general, the decision maker must seek to elicit the general background of the applicant, including his family circumstances and history, his educational background, and his activities during the previous few years. Ethnic and cultural information may also be important. If there's reason to doubt the applicant's statement as to his age, and really that reason is going to come from appearance in the first place. The decision maker will have to make an assessment of his credibility, and he will have to ask questions designed to test his credibility. Following Fee and Merton, there has been, of course, a lot of case law. We could have put hundreds of cases in the bundle making points about procedure. And in AB and Kent, which is tab 10, we'd reached the stage where there was almost a statute had been developed. At paragraph 21 on page 754 of the internal number. There was a list there of the relevant guidelines of all the things that are the most desirable in a full-scale assessment. Mrs. Justice Thornton, however, was considering a case where Kent were of the view that the young person before them was over 25. And the submission was made to her that that wasn't sufficient, that there should be bigger guidelines. She rejected that submission. Paragraph, well, I've highlighted paragraphs 31 to 34 and 36 and 37. I think those are highlighted at the request of Laing in particular to emphasise the difficulties of assessing age. And at paragraph 44, she ruled that whilst it may be legitimate for a local authority to assess age based on an abbreviated assessment of physical appearance and demeanour, it is incumbent on the authority to ensure that any such decision takes into account the margin for error in the abbreviated nature of the assessment. Mr. Rule sought a ruling from the court that as a matter of principle, an initial assessment based on physical attributes and demeanour should not be treated as determinative by the local authority unless it concluded that the person in question was 25 years or older. In response, I contended that this would radically alter the way in which local authorities currently conduct assessment using the benchmark of 18 years and would have significant resource and cost implications for a local authority like the defendant. In Merton, Bennathan J warned against judicialisation of relatively straightforward decisions. And she said at the end of that paragraph, I do not consider it appropriate for this court to specify a permissible margin of error for initial assessment by local authorities based on physical appearance and demeanour, not least it seems to me because the margin of error may depend on the circumstances of the assessment.
So this was a case in which the local authority had assessed the age as being between 20 and 25 years.
That's right.
And there were, Mrs. Justice Thornton made various criticisms of the process that had been adopted by the local authority in reaching that conclusion.
Yes, in particular, because they assessed him as being 20 to 25, the margin of error being 5 years, it could have been as little as 15. It could have been 15 to 20. So that was the worry in that case. But she didn't adopt Mr. Rule's submission that unless they're 25 or older, there must be a full-scale assessment, and there must, unless the local authority initially thinks they're at least 25, there must be a full-scale assessment. And in the meantime, of course, the putative young person taken into local authority care and accommodated as if they were a child.
So where do we see that in the judgment?
So that's paragraph 45.
45.
Even where the local authority thinks that they're clearly an adult, as much as 25, and it would be in such circumstances a worrying development to place older young people with, when a local authority is accommodating a child, they are clearly vulnerable because they are children in need. So ex hypothesi, they are vulnerable young people. Following that, Mr. Justice Swift looked at that kind of statutory list of what fairness requires and held, of course, that there isn't a one-size-fits-all process. That's paragraph 31 in his judgment at page 1794 in the next tab in the bundle.
Sorry, which paragraph?
So at 31, he mentions he approves the judgment in this particular case, in fact, and I also have no problem with the bit quoted there. The depth of inquiry required of a local authority is not binary. The approach is neither one size fits all nor two sizes fit all. The correct approach in all cases starts with the principles identified in Merton. What is required in each case depends on the circumstances for that case. Checklists can be useful aide-memoire, but they are not rigid prescriptions. If the case is an obvious one, what is required by way of reasonable inquiry may be brief. There will be some instances where lawful decisions can be taken on the basis of appearance and demeanour alone. In other cases, investigation will be required. When further investigation is required, whether that need take the form of a single interview or more than one interview, or whether the investigation need consider the views of other relevant professionals, for example, residential social workers, must depend on the circumstances of that case. The important matter is that the obligation on the local authority is one of reasonable investigation. Reasonable does not mean exhaustive, and what is reasonable is specific to circumstance. My lady, I endorse that paragraph wholeheartedly. If the investigation does comprise one or more interviews with the person whose age is being assessed, those interviews must be conducted fairly. What is necessary for this purpose must take account of the circumstances of the person, for example, whether an interpreter is required or whether he should be given an opportunity for an appropriate adult to be present, and that's whether. At paragraph 33 at the top of the next page, the Council's submission in this case is that the full Merton compliant checklist that we looked at in AB and Kent has become too long and too onerous to be applied in every case where an age assessment needs to be undertaken. Hence the contention that there's some other shorter checklist, short form assessment, that's both sufficient as a matter of law and manageable in practice. However, any such prior prescription would be hostage to fortune because the requirements of fairness are sensitive to circumstance. A better approach is for the local authorities to determine the scope of the reasonable investigation step by step. In practice, this is what happens in most cases. In any case where there's cogent documentary evidence that the person is not a child, that may be both the beginning and the end of the inquiry. When that is not so, likely to be most cases, the social worker or workers undertaking the assessment will ordinarily meet the person concerned. That will start the process. And the social worker will need to decide, as the investigation progresses, whether the information reasonably required for decision has been identified, or whether further, and if so, what steps are necessary to obtain information that's reasonably required. True it is that the ultimate decision on whether a fair procedure has been followed is one for the court, but that court decision will also be made paying close regard to the explanation given by the decision maker for why some steps were taken and others were not. As Bennathan J put it in his judgment in this case, local authorities should not be hobbled by the courts taking a highly technical approach, demanding that every box is ticked, but should instead allow practical and flexible procedures to be deployed. And, my lady, although Mr. Justice Swift was able to point to the judgment of the court below in this case to support his ruling in that case, which I think is absolutely correct, in my submission, what happened in this case was that a different standard was in fact applied by Mr. Justice Bennathan when he considered what had happened in this case, and that if his ruling is put into effect, it means effectively that the moment you start talking to a young person you need to have the full panoply of that checklist in place, and there's no possibility of social workers carrying out.
Well, he doesn't quite go that far. What Mr. Justice Bennathan did in this case was to identify 3 failings, which he said made the assessment unlawful. So it's not quite as well, at least at the moment, I don't see that it's quite as drastic as you're suggesting.
My clients are in the position of having been told that what they did when they decided that SB was clearly and obviously an adult way outside the margin of error was unlawful because it was unfair.
Yes.
And they are in the position where they are going to have other young people coming along in a similar circumstance, and they would be unable to adopt the same procedure without fear of being challenged on the same basis. And it's just for that reason that they bring this appeal and say that it is not an academic one for them. It's very much a live issue that affects their day-to-day conduct of age assessment cases.
All I was suggesting to you, Ms. Rowlands, was that your submission about the effect of Mr. Justice Bennathan's decision is perhaps not quite as drastic as you're suggesting, precisely because he only identified 3 specific respects in which he said that the procedure fell down.
But there are 3 specific areas that arise out of his starting point, which is not the starting point identified by the social worker.
No, that's a separate. Anyway, don't worry. That's a separate point. All right. Sorry, I apologise for interrupting you.
The question is, what is a social worker to do in these circumstances that they didn't do in this case? Where they were so satisfied that SB was clearly and obviously a young man, an adult, not in need of children's services, and those 2 are very much linked. That in what way did they err when they told the court that they were absolutely sure that this was an adult? Appearance is sufficient to found a Merton compliant assessment in clear cases. And I've taken you both to B in Merton and to AB in Kent, which are 2 parts of that. The social workers in this case were very cognizant of the margin of error and the way that their role fits within the grey area. They were sure that he fell outside the grey area. They were sure that this was a case where they didn't need to go any further to ensure fairness than they did go in this particular case.
I mean, there's quite a careful explanation in the assessment, which I've read, of the reasons why the social workers didn't consider that an interpreter was necessary, and of the steps they took to ensure that the claimant, as he was below, understood everything they were asking. Is there any reference to the question of appropriate adult in the assessment?
I'm not sure that there is, but it's all part of the same question. What is necessary to assure fairness when basically they've taken one look at SB and decided this is an adult?
So where does the role of the appropriate adult come from? Is it set out in any guidance?
Yes, the guidance comes from the ADCS guidance,
Right.
and then has been put into case law. You get this kind of circularity of the guidance being adopted into case law and the case law being adopted into guidance.
Right, so what I'd be interested in, because as you've already told us, the ADCS guidance doesn't in and of itself have any legal status. I mean, it may be a relevant consideration for a local authority doing one of these assessments,
Yes.
is there any relevant case law about the role of the appropriate adult?
There's some, and I've cited.
I mean, if I'm taking you out of your plan, we deal with it later if you would prefer to do that. But it is a question.
Well,
I'm
both of us
interested
have
in.
given you some case law on
Yeah.
that.
Is there anything you particularly rely on? You want that you say supports your approach?
At paragraph 33 of my skeleton argument, I've cited a decision which we didn't put in the bundle of authorities because we were trying to keep it down to 10.
Right.
AK and Secretary of State for Home Department. It's Miss Andrews as a Deputy High Court Judge back in 2011. And she notes that the presence of an appropriate adult is best practice, but it is not part of the Merton guidelines.
Right.
Sorry, what page of the...
It's in my skeleton
bundle.
argument, which is in the core bundle at page 17. And so it's at page 27.
Sorry, which paragraph of the skeleton is it? I thought you said 33, but that's something quite different.
36. I know.
I might need to assist because we received a perfected skeleton argument. I don't know whether or not that's in this bundle because I don't. We received that on 5th of June.
Oh.
So I think that is the additional paragraph that was added in by my learned friend into the perfected skeleton.
Sorry. Is this the skeleton? So are you referring, Mr. Rhodes, to the skeleton argument dated the 23rd of May 2023,
I think there's
or a later, or an even later one?
So may I just turn my back a moment?
Yeah.
So,
Yes.
my lady, I think the bundles that were sent to court yesterday. had
Yes, which
my-
we haven't received, unfortunately.
They were couriered to the court.
No, I know it's not. I'm not blaming you. I'm just saying we haven't. You know, as a matter of fact, we haven't got them. No blame attaches. So what's the date of the later skeleton argument, please?
Unfortunately, mine's dated the 1st of June, but I know that's just because that's the date I printed it out.
All right.
Would it assist? I do have a clean copy, but except for the fact that it's highlighted the additional bits in the perfected skeleton. I don't want to seem to influence the court at all. But that is the clean copy.
Well, I think we can get copies printed at lunchtime. It's just a bit unfortunate. There's been this flurry of late stuff and it hasn't reached us.
Yes, my version that I was provided was the 5th of June.
5th of June. Okay. All right, that's very helpful, Miss Lou. All right, well, so let's just get a note. So in paragraph 33 of your skeleton argument dated the 5th of June, there's a reference to a relevant case about the role of the appropriate adult. But it's a decision of Miss Geraldine Andrews, QC, as she then was, sitting as a deputy. Can you just give us the reference, please, again? I think you said it was in 2011.
AK and Secretary of State, 2011, EWHC 3188, admin.
Lovely.
My lady, I've got one copy here that's got no marking on it.
But I think you've read out, I mean, you said that what she said was it's best practice, not a legal requirement.
That's right, yes.
Yeah.
And it's always a question of, if so, so what? If there is no appropriate adult there,
thank you.
what is the impact on the fairness of the procedure?
Yeah.
And in this case...
And I suppose we need to know what an appropriate adult would do,
Yes.
so as to be able to reach some kind of view about whether or not SP should have had one present.
This is, again, the context of it being a Children Act determination. It's not immigration.
No, I understand that, and I understand, as I understand it, the passage in the judgment that quotes some guidance about appropriate adult is from the criminal context. Is that right?
Yes.
Yeah. Okay.
The ADCS guidance at the last tab in the bundle of authorities
Yeah.
explains it a little bit. To start off with, just to look at the cover at the beginning, this explains that it's guidance to assess social workers and their managers in undertaking age assessments
Okay.
in England. It's dated October 2015,
Yeah.
and so is somewhat well, getting on a little bit.
And would you accept, Ms. Rose, that that this guidance is a relevant consideration for decision makers, even though it has no statutory force? That's helpful.
At page 223 at the top, introduction. The age assessment is a challenging process. This document is designed to address the gap there has been in national guidance on this topic by providing user-friendly practice guidance to social workers. And then at chapter 1, the first question that is asked is it absolutely necessary to undertake this age assessment? Is this a clear case one way or another? And a needs assessment should be separate from an age assessment. So the points that I have been talking about. It talks about planning and preparation, which is obviously...
Sorry, could you give me the page reference to? Oh, I see. It's page 225. Yeah, thank you.
And then at page 236, an interpreter and appropriate adult at the bottom. The appropriate adult must be independent of the local authority, have relevant skills and training to undertake their role, and be experienced in working with children and young people. They need to be clear and confident about their role, have the skills to support the child or young person in the interviews, and challenge social workers if they feel the interview is not being conducted appropriately. They should advocate on behalf of the young child or young person, represent their best interests, and ensure that the child or young person's welfare needs are met during the interview process. Where relevant and possible, gender issues need to be considered when making arrangements for booking the appropriate adult. And then it says, for more information, see Appendix J. And in fact, it's not Appendix J, it's Appendix I. And that's at page 267. And the first paragraph says it's a legal requirement that a child or young person is offered this support. I don't know where that legal requirement is said to come from, other than to ensure the fairness, generally speaking, of a process if it is required in any particular case. To ensure the interviews are conducted transparently and appropriately, comply with the principles outlined in case law. My lady, you've got the footnote there. These are summarised in AS and Croydon. That was then taken on to AB and Kent, so you've got the same list but with more desiderata added onto it as well. They should ensure that the assessment interviews are being conducted in an appropriate setting and conducted in a structured, fair, non-adversarial, non-stressful and informal manner. Conducted sensibly with the child or young person in accordance with her or his particular needs, paying attention to both verbal and non-verbal communication. This may include asking for a break where a child or young person seems stressed or upset, ensuring, for example, that they're not thirsty, hungry or tired during the interviews, and it may also include interrupting the direction of questioning that it is not relevant to an assessment of age. They should ensure, so far as possible, that the child or young person understands the questions being asked of them and should give support to clarify questions being asked of the child or young person, but may not coach or answer for them, and taking notes of that.
Are you saying there's anything, as it were, wrong with that guidance? I mean, apart from the point you've just raised about whether there's a legal requirement, and if so, where it's to be found. I ask that because the impression I got from your skeleton was that your case is the appropriate adult should not intervene at all in the process. But this guidance envisages all sorts of circumstances in which that is precisely what the appropriate adult needs to do.
The appropriate adult would clearly appropriately intervene if there was a need for a break, for example, if there's some need for support being evinced by the young person, but not intervene to give answers on behalf of the young person, and not intervene to coach them or to make sure that they were giving the right answer.
No, I quite understand that, but I mean, the proposition as it was put in your skeleton seemed to me rather more extreme than that. I'm sorry, I may have misunderstood it, in which case I apologise.
Well, my submission is that what Mr. Justice Bennathan did was bring over the role of an appropriate adult for
But how much
a criminal case.
how much of a substantial difference is there between what's said in this guidance and the guidance that Mr. Justice Bennathan quoted?
There's a key difference, which is that in a criminal case, you're in an adversarial setting, and you've got potentially, obviously, criminal consequences.
No, it's a more focused question than that, Ms. Rose. I'm asking you, what difference of substance is there between the material which Mr. Justice Bennathan quoted in paragraph 36 of his judgment and this description in the guidance of the role of an appropriate adult?
What he said was that the appropriate adult would have been able to intervene in the interview process and tell him effectively what to say, because if I just go to the judgment now,
All right. So it's paragraph 37 you're relying on, first sentence. He says, in my view, the suggestion made on behalf of the defendant in argument that the appropriate adult was not allowed to interfere in the interview is simply wrong.
the starting point is the question of what is meant by interfere. So the submission that I make is that yes, I stand by the submission that an appropriate adult should not interfere in the interview. They shouldn't be playing a part in the interview. They should. I've got another question there, which is this actually an interview? Is this part of the assessment process that is properly qualified as an interview? And the Home Office guidance that Mr. Justice Bennathan referred to in 36 is to say that you have a positive and important role. You should not expect to be simply an observer, and you are being asked to be a proactive, have a proactive stance if you're in a police interview. In this case, it's a supportive stance, a reactive stance. And I wouldn't qualify saying, shall we have a break now, as interfering in the interview. What I would say is interfering in the interview is trying to give trying to clarify what the claimant had said. Had the claimant been accompanied by a sympathetic adult?
Well, hang on a minute. The guidance that the Directors of Children's Services guidance says in 1, 2, 3, 4, 5, fifth paragraph down, sure, as far as possible, the child or young person understands the questions. They should, when necessary, give support to clarify questions being asked of the child or young person, but may not coach or answer for them. So how? Go back to the question I asked you, which is how in substance does this differ from the guidance that was quoted by the judge?
Well, my lady, what I say is that the judge then carried on to say that the a sympathetic adult could have played a role in avoiding misunderstandings, which were a basis for social workers to disbelieve what he was telling them.
Yeah.
There are so many flaws in that one sentence. First of all, this wasn't an interview in the sense of trying to establish the claimant's history and background. This was checking his demeanour and whether it in any way, whether he was able to say anything that would contradict this strong view formed by the social workers on the basis of his appearance. Misunderstandings that were used as a basis for the social workers to disbelieve what he was telling them. They weren't disbelieving what he was telling them, they were setting it against his appearance and demeanour, and were setting his appearance and demeanour as being the clear reason for their decision. The reason for their decision that he was clearly and obviously an adult was not anything about misunderstandings or disbelief or anything like that. It was a clear decision based on his appearance, his demeanour. Nothing in the claimant's grounds or skeleton argument below made any case that the lack of an appropriate adult, in this case, made any difference to the fairness of the procedure that the social worker should be aware of at that time. My lady has already pointed out that the age assessment makes it clear that the social workers made every effort to ensure that SB was able to understand what they were saying, that he was able to communicate with them freely, and they showed their working in relation to that.
But,
And in those
sorry, can I just, I'm so sorry to interrupt, Ms. Rose. Can I just ask this question? You mentioned the grounds for judicial review. Where do we find them in the bundle, please? The core bundle's got the claim form, but doesn't seem to have the grounds attached to it, or have I missed something? Are they in the supplementary bundle?
They are in the bundle that I've got.
Sorry, I might be able to assist. In
Yes,
that
please.
Bundle, it's page 232 of.
Page 232.
And I think Lady Justice Falk's clerk had asked about the numbers pages, and it's page 232 is where my learned Jean.
Okay, on the electronic.
Right.
But they weren't apparently in the original bundle.
No, well that's why I asked the question, because I don't think
That's
they've
why
reached.
we
I don't think
flagged
they've
that.
reached me. Let's just check.
Actually, I had thought that as a placement.
Oh no, sorry. I'm so sorry. They are here. They're just in a place that I hadn't appreciated where
Yes,
they
I've
were.
got them too.
No, it's my fault entirely. I'd expected to find them attached to the claim form, and anyway, all right, my fault entirely. Thank you very much. Well, do we need to look at the statement of factual grounds for this purpose?
Well, perhaps if you do, I'll leave it to my friends to draw your attention to.
All right.
that particular.
Okay, well, it's helpful to know where those are, and I'm sorry for having missed them on my first look at the bundle. Right. Yes, I'm so sorry I interrupted you, Miss Rose.
Well, I think I would like to circle back to my ground one
Yeah.
and to the starting point for the question of what fairness demands in this case. The age assessment, which was carried out by Ms Hughes and Mr McCosson, was short but complete, and in my submission Merton compliant, because it proceeded on the basis that the social workers, having met SB and spoken to him to establish a little bit about his demeanour in particular, how else can you establish demeanour without talking to somebody, stated that they were absolutely sure that he was an adult. They made that throughout. It is obvious from SB's appearance, they say, that he is not a child or young man in his early 20s. At page 258 in the Bible, in the assessment, they make a description of him. Physical appearance, demeanour and interactions. He's a tall man, large build, large features. His hairline is receding, the hair on the top of his head is thinner than 17-year-olds, suggesting he might be losing his hair. The areas of his head where his scalp is visible. He has some grey hairs. He has pronounced lines on his neck. These are evidence of the ageing of the skin. We have not seen such lines on a young person around the age of 17. These are typical of an adult who is significantly older. He spoke in a deep, rich, confident voice, which again indicated he was older than 17. In his communication, he was calm. He engaged in a way that felt like an adult speaking to equals rather than a young person, speaking to people who are older than him. Simon was calm and reflective. At the end of the session with Simon, when the assessors explained to him that they could not accept him as a child, he calmly and assertively said, "How can you tell me my age? How could I not look like a child?" The assessors described their observations of his physical appearance, and he appeared to accept this. Simon conducted himself
I'm
during...
sorry, my lady.
Yes?
I think there's an anonymity order, and
Oh, sorry, did you say
Oh, sorry,
something
I've
about...
been saying Simon. I started off
no.
saying SB.
I do apologise for
No,
interrupting.
no, you're quite right to interrupt, and I'm sorry I didn't spot it myself. Thank you very much, Ms. Lou. Yes, so please try and...
Yes, he conducted himself during this interaction in the manner of someone who is confident in expressing his position eloquently with unfamiliar people and able to manage his emotions and affect. The assessors are not used to observing such sophisticated communication and emotional regulation in 17-year-olds. The impression that the social workers gained of SB was that he is much older than 17, and they set out their experience of working with unaccompanied asylum-seeking children and other young people of a range of different ages, and in particular of the same background. They acknowledge that some 17-year-olds look older than others and are conscious of factors that might influence this, such as stress, time spent outside in the elements, and experience of physical work. Even when these factors are considered, SB looks years older than any other 17-year-old Sudanese male known to them. In the next box below that, under the heading 4, the social workers have considered the information that they obtained during conversations with him and considered Home Office documents. We recall that the Home Office had accommodated him as an adult. They were therefore of the view that his appearance and demeanour very strongly suggested that he was significantly over 25.
Have we got any of the Home Office documents in the bundle?
Is it in the core bundle? I'm not sure it is, no. Quick look through to see whether we included that in. Going back to the middle of that box, the social workers felt that observations of SB's appearance and demeanour provide sufficient evidence for them to conclude that he is an adult. The Home Office have confirmed that they considered SB to be an adult because his physical appearance and demeanour strongly suggested he was 25 years of age and over. The key sentence in the middle of that is, they felt that observations of his appearance and demeanour were sufficient evidence. This was one of those cases where it was at that end of the scale, where it was sufficient for them to conclude that he was an adult. Over the page at 260, in the middle of the observations of appearance and functioning, it is obvious from his physical appearance that he is not a child or young man in his early 20s. He doesn't appear to be close in age to relevant comparators. The assessors are bringing their wide-ranging experience from social work and particularly relevant experience of people from a similar culture and background to the decision-making process. Consideration has been given properly to whether SB should be given the benefit of the doubt and accepted as a 17-year-old. The assessors are unable to do that because his physical appearance suggests that he's many years older than 17. They would be prepared to give him the benefit of the doubt if he looked slightly older than 18 or in his early 20s. However, as he looks so much older than 18, they do not consider that there is any doubt that he is an adult. So this was a case where they were absolutely certain that he was outside the margin of error, outside the grey area, and they could be certain that no further investigation was needed before deciding that he was not a child or a child in need of support. And at the bottom of that page, we emphasise again, the assessors primarily rely on their observations of Simon's physical appearance to make a determination of his age.
Ms Rowlands, can I just remind you about the anonymity order, please?
From his physical appearance, including development of facial features, hairline, skin complexion, and physical body size and shape, it is abundantly clear that he is not a child. The assessors acknowledge that basing an assessment of someone's age on his physical appearance is not a task that can be completed with a high degree of precision, but they are able to say with confidence that he is not a child. This is work by social workers who have looked at the existing case law, in particular AB in Kent, and have taken cognizance of the margin of error and the need to be clear before you make a decision based on appearance and demeanour, that you have got to be clear about the margin of error, recognise it, and this assessment clearly recognises the margin of error, takes it into account and says, having looked at all of that, this is not a case where there is any doubt for him to be given the benefit of. In the middle of the next paragraph, the assessors outright reject the possibility that he was born in 2004, as he stated. The Home Office allocated a year of birth of 1996 to him. The assessors don't know how the Home Office reached this conclusion, and therefore don't know how strong their evidence is. However, as the assessors feel that SB is at least 25 years old, they're content to allocate the same date of birth that he was allocated by the Home Office, 25th of May 1996. That's the background, that's the basis, the baseline from which we assess fairness and what fairness required in this case. However, the judge below mischaracterised what they were saying. He said at paragraph 6.2 of his judgment that they thought he was perhaps as much as 7 or 8 years older than his claimed age. That perhaps is a gross misrepresentation in my submission of what they were actually saying. They were absolutely clear. There was no perhaps about it.
Sorry, I'm so sorry. Could you just remind me which paragraph that was?
6, subparagraph 2. It's on page 95 of the core bundle.
Fine.
I need to correct one error in my skeleton argument. My footnote 2 says he removed the word likely from paragraph 6.1 after receiving my correction to the draft judgment. In fact, the word he removed was initially. So in paragraph 6.1, he initially said their initial view was that the claimant was significantly older than he claimed. And I pointed out that initial seemed to suggest that they changed their mind, which was far from being the case. So he took that word out. He then went on to say at paragraph 2, on the basis of his appearance and manner, both social workers believe the claimant to be well above the age of 18, perhaps by as much as 7 or 8 years. In the light of their view, they stated that they had not conducted a full Merton-compliant age assessment. Now, my lady, my submission is that the judge took that as an acceptance that they hadn't conducted a fair assessment, that he was equating full Merton-compliant assessment with the only fair way of conducting an assessment. That seems to be what he took from that. That is, in my submission, a wrong understanding of full Merton compliant age assessment. It was a Merton compliant age assessment in my submission because it did all that was needed in the circumstances where it was clear from physical appearance and demeanour that he was obviously an adult.
Yes, well, I mean, the reasoning in paragraph 62 is quite condensed, and it depends on how you unravel that concision, I suppose. All right.
Yes. If you start adding in interpreters, whereas in this case the views of the social workers were that there was no need for an interpreter, that there was a need for an appropriate adult, and that there was a need for a separate mind at two process, then you're moving out of the area of a Merton compliant assessment on the face of appearance and demeanour alone, whereas these social workers were saying basically it was appearance and demeanour satisfied them so that no further inquiry was necessary.
So you're saying that's in effect failing to recognise that in his judgment, Mr. Justice Stanley Bennathan had accepted that there were some cases where the full panoply might not be required.
I'm sorry, could you go through that again?
Oh, sorry, it was a very
I'm sorry.
convoluted question. Your point is that formulation doesn't recognise, or potentially doesn't recognise, the distinction in the Merton judgment between cases which might require more investigation and safeguards and cases that might not.
Yes.
Okay.
Yeah. Although I do adopt Mr. Justice Swift's comment, it's not a binary, it's not a distinction between.
Yes, well, Mr. Justice Bennathan recognised that as well.
He does say that, but my submission is that reading his judgment, he's not really applied what he's actually said as to the law.
Yeah, well, that's a separate point.
Yeah. Would it be fair as a general comment to say that you accept that Mr. Justice Bennathan, on the face of it, directed himself correctly about the law, that it's then apparent from the way he dealt with the case that he didn't actually follow the guidance correctly?
My lord, yes. Generally
So
speaking,
you're
yes.
not pointing to any specific misdirection of law as such. You're saying, just read as a whole, this judgment shows the judge has misunderstood the task he had to carry out.
My lord, that is in effect my submission, yes.
And I'm not trying to put words into your mouth. I
No,
just want to be
but
clear.
that's the general. That's the
general
import
thrust
my
of where you're
submission.
going. Yes.
Yeah.
Thank you.
And his judgment, substituting the word perhaps for absolutely certain, puts him on the wrong foot for applying his own analysis of the law, because he's really applying the law to a different case than the one that was actually before him. And again at paragraph 32 in his judgment, which is the non-binary paragraph on page 104. He says, in this case, the local authority is dealing with a young person who their suitably qualified staff regard as very likely to be older than 18. And again, he's watering down.
Yeah, so that's an understatement of their actual conclusion.
Very much an understatement, yes. In argument, it was conceded on behalf of the defendant that once the social workers decided the claimant's assessment required an interview, that interview had to be fair. So what do we mean by interview and what do we mean by fair in those circumstances? This wasn't an interview that was designed to elicit the kind of thinking about history that Bea Merton talked about. We went to that some time ago. This was about establishing his demeanour and about looking at the basics. How fair does the process need to be against this background and in circumstances where the social workers were absolutely satisfied, of course, that SB was able to understand them and speak for himself.
I suppose it might be said that considerations similar to the considerations which the social workers took expressly into account about the issue of whether or not an interpreter was needed might not be identical with, but might feed into a question of whether an appropriate adult was necessary.
Yes, I mean, they noted in this case that SB was confident, able to speak for himself, and able to handle questions without any need for an appropriate adult. It was a short period of time, so questions of breaks and questions of food and drink were not terribly important. And we note that, for example, at page 259, the second paragraph there, once he got talking, he began to be confident enough to provide long answers to questions. Sometimes he gave fuller answers than the questions required. It appeared there were certain things he wanted to talk about.
I'm so sorry, Miss Rose, this is my fault. I've taken out of the wrong bundle the assessment, so I've got it separately. So could you just give me more help than the bundle page? This is all my fault, because the pagination of the one I've got starts at A230.
It's the section above section 4.
Right, that's very helpful. Thank you.
Paragraph above.
Thank you.
It's an 8-page document. I've now added page numbers to internally, so it's page 5.
Page 5, lovely. That's really helpful. Thank you.
He didn't appear to find it difficult to answer the questions, except when he was visibly upset about missing his mother. The way in which SB engaged with the assessors during the assessment was more typical of an adult than a child. He appeared to be quietly confident, didn't appear to be stressed. And again, this is against the background of these being experienced, suitably qualified social workers who've done this before. They've done work with other young people and are able to compare and contrast this young man with other people of similar background, similar age.
Can I just ask, you say that the aim of the discussion, I won't call it interview, was to assess demeanour and appearance, yet they did ask SB about his history and obviously went into some detail.
They did.
About that.
Well, first of all, yes, they did ask him questions about that, but the key point was still this was someone who they thought was clearly and obviously, from his appearance and demeanour. Appearance in particular. Demeanour is something that you then assess from interaction with somebody. You can't...
Well, yes, I appreciate to do that you need to talk about something. I'm simply pointing out that there was a lot of discussion about the history.
Well, for example, at the top of page 5 of the assessment, 259 in the bundle, they acknowledge that appearance can be influenced by factors. So, stress, time spent outside in the elements, experience of work. It's important, therefore, to make sure that there's something like that that's affecting the assessment of appearance, and those factors had to be considered. There were credibility points, but those weren't central to the decision-making process. The central point was his obvious adult appearance and demeanour.
So what was the point of this interview? I mean, if they'd already made up their minds.
They had to meet him to start off with. They had to meet him. You can't assess somebody from a photograph. I'm not going to stand up. Well, I suppose certain photographs, if you had a picture of Dumbledore or Gandalf with a white beard down to their ankles, you might not want them to go on to. But someone who got the photograph of SB, page 257.
That photograph was taken in the interview, wasn't
That
it?
was taken in the interview.
So they didn't have it beforehand. And as I understand it, they'd had one or more telephone conversations with him for the interview.
They had, yes.
So the assessment refers at one point to conversation and at another point to conversations. So
Yes.
was that dealt with in the witness evidence?
Yes.
If you just give me the reference to it, please, I can look at it later.
you've got the witness statements of both assessors at pages 83 and 111 of the supplementary bundles.
Thanks very much.
It's Mr. McCrossan at 111 who had the first contacts with SB.
Okay. Thank you.
And he also spoke to Miss Nanton, the former litigation friend in this matter, and she'd spoken to him in English, and he'd been...
Well, I picked some of that up from the terms of the assessment itself.
SB initially didn't say much. Mr. McCrossan then said, well, I've spoken to Miss Nanton, and she tells me that you can speak English, and then he did speak English to Mr. McCrossan, using full sentences and answering questions. It was difficult to find a newer interpreter, not just for those instructing but for the other side as well.
We've read the assessment.
Southampton as well. The witness statement records that the assessor thought that SB had been deliberately hiding his ability to communicate in English. We talk about the process of the assessment in very short terms in the witness statement. That the witness statement of Mr. McCrossan says at paragraph 8, we made extensive efforts during the meeting to ensure that he was able to understand us and communicate meaningfully with us. Our efforts to do this are described in the age assessment. It's really the age assessment that stands as a document in its own right.
Yes.
And it's communication that's important when we're talking about the fairness. He was able to express himself, he was able to understand what was happening, he knew what had happened about the assessment, and you've seen the comment that he made, how can you tell me my age, how could I not look like a child? And he was explained how you could challenge it, and of course he then did instruct solicitors to challenge it. But because Mr. Justice Bennathan had re-qualified what the assessors had said, it fundamentally changed the nature of what they were doing in relation to fairness. And so he misinterpreted the need for fairness to have extra bolstering by the process that they carried out in these circumstances. His starting point should have been, first of all, what did the assessors themselves think? And was that a decision that social workers were entitled to reach in these circumstances? He can only answer that question, and of course it is a question for the court in the final determination, on the basis of what the assessors themselves say, not what he said that they said. So that error in my submission undermines the judge's decision as a whole, and it also undermines the way that Kensington and Chelsea are able to deal with people who appear so fundamentally to be an adult, because they are concerned that the same approach will be taken by other judges in the future. Are they able to carry out an assessment of someone as being clearly and obviously an adult without having to go through the process of obtaining an appropriate adult? It's an unusual case where you don't need an interpreter. Not so much concerned about that. It's an unusual case where you can't get an interpreter either. But this is a case that stands on its own in relation to that. But the judge said at paragraph 32, which we were just looking at, once the social workers decided the claimant's assessment required an interview, that interview had to be fair. I went on to say, for a given of fairness as what requires in the actual context of this assessment and the weight to be given to these.
So in other words, you're saying the judge's misunderstanding of what the social workers had decided influenced his view about what fairness required on the facts of this case. Is that it?
That's it. And that he failed to give due weight to the social workers who are carrying out that assessment, because they are social workers, they are the primary decision makers. And the whole sort of statutory scheme that's developed, non-statutory scheme that's developed about age assessments, gives prominence to the role of social workers for a reason. in age assessment, the better the quality of the decision maker, the better the quality of the decision, and the less likely the court have to intervene. These are the people who've got the training, the experience, and the sensitivities necessary to carry out an age assessment. And significant weight should be given to the fact that these are social workers who are making this assessment.
You've explained why your clients are concerned about the implications of this judgment if it's left unchallenged. Might it be fair to say that that concern is possibly heightened by the approval we find in the Mr. Justice Swift's subsequent decision, which appears to endorse, indeed does endorse, what our judge said about the law, and that might, there's perhaps a risk that might then be taken as a full endorsement of every aspect of his decision.
That is the case. I've certainly been involved in other age assessments where this case has been cited, where I've had to advise other local authorities about the implications of this case. But I think Mr. Justice Swift picked the best bits out of this judgment, and I don't.
Well, all he was referring to were two statements of the law,
Yes.
and he's perfectly entitled to approve those statements because I would have thought they're uncontroversial.
I think so, but I, as I say, I have had SB cited.
I think that's the point.
And of course, yes,
My lord was making.
I am concerned about the impact of this on other local authorities as well as my own local authority carrying out further assessments.
Yes, I mean, this will of course tie into the argument when we come to it on whether the appeal is academic. I mean, if there are genuine grounds of concern which need to be resolved, that could be a strong argument for saying we ought to decide the appeal on its merits and not just on the question whether it's academic.
The real reason why my clients think that this is not an academic appeal is because it's not about what happened with SB, it's about how they...
Yes, it's about the process generally. It's a
yes.
decision of a High Court judge commenting on the process that's necessary in these cases. Okay.
Whilst I'm talking about whether it's academic, there are two other small points.
Yeah.
The first is that although Southampton have accepted SB's age as far as they're concerned, that doesn't tie Kensington and Chelsea's hands any more than any other local authorities would. And what it means is that if SB wanted to come and live in London at some stage, he could come back and say, you never properly assessed my age. You should have assessed me as being 17 when I presented to you. I would then have been a child in need, and you would have had duties to me as a former looked after child.
A former looked after child, yeah.
But you messed me about. You didn't assess my age properly. Look, the court has said so. So you now need to accommodate me as if I had been a former looked after child in order to compensate me for the wrongdoing that you did there. So if you wanted to come and live in London, as many people do, and live in Kensington and Chelsea, as many people do, he might come knocking on the door and we might then be in judicial review all over again.
So as a former looked after child, just very briefly, what services might he get?
A former looked after child, if he'd been accommodated by this local authority for a relevant period of time, he would have an entitlement to advice and assistance in relation to, he'd have a personal assistant, probably accommodation, as long as he remains in education and training that need him to be accommodated and supported by the local authority.
Okay, that's helpful, thank you.
And in terms of a homeless application, if you were to apply as homeless, having been granted status by the Secretary of State, and he would then be entitled to homelessness assistance under the Housing Act 1996.
So would he have priority in the allocation policy?
He would have priority as a homeless applicant. I don't know about Kensington's allocation scheme, I haven't looked at that entirely.
Right.
But care leavers have priority under the Part 7 of the Act.
Okay, that's helpful, thank you very much. That's
And
Part
of
7
course-
of the Housing Act 1996?
Sorry,
Part 7 of the Housing Act 1996?
1996.
Yeah, thank you.
And of course, the third reason why we say it's not academic is the costs, but that's the make-weight using.
Sorry, I'm so sorry, I didn't catch the
costs.
Oh, costs, yeah. Well,
It's slightly shamefaced submission, but it does matter, of course.
yeah, but I mean, there's law about whether if costs is anyway. Yeah, okay.
But there's the two main reasons why we.
Yeah. So you say it's got a wider importance than simply the dispute between SB and your clients. Okay.
My lady, I'm aware that I've been going for nearly 2 hours now, so I'm going to hopefully be able to deal with ground 2 and ground 3 fairly quickly. I think
To be fair, you've had a lot of interruptions, which have most of them my
I've
fault.
dealt with most of them anyway. The learned judge failed to give due weight to the assessment of the social workers that the claimant was able to manage despite an interpreter. He said he had no reason to believe that the claimant was not able to carry out a conversation in English, and that's paragraph 33 of the judgment.
Right, sorry, just let me find the judgment again.
So it's page 104. So again, he starts from the right place. The assessors found that the claimant was capable of conducting a conversation in English. Once more, I have no reason to question that assertion. But he then goes on to say, I note that a person's command of English may ebb and flow depending on whether they're tired or distressed. So he then goes on to say, I've got no reason to doubt what the assessor said, but then finds a reason to doubt what the assessor said.
So in other words, he's bringing his own experience and knowledge to bear on the question.
To override what the social workers have said. Demeanour, and appearance is something that's fairly objective. You can say someone's got brown eyes and grey hair, and that's fairly objective. Demeanour is more or less A, objective, and B, able to be reduced to writing. And somebody's demeanour about their age is as much an impression as anything. And it's very hard to put that in writing. And how they understand things as well is something that the assessors are best placed to appreciate because they're the ones who they're face to face. It's like a judge hearing a witness. They're the ones who are best placed to appreciate.
But it's just in short, it's clear from the terms of the assessment that the assessors were aware of this as a potential issue and took steps to ensure that he was understanding what they were asking him.
My lady, yes. In my skeleton arguments, I've given you 6 examples of what they did to A, work with him, and B, make sure that they were checking their workings.
And can you remind us which paragraph that is?
Well, it's paragraph 47 in my skeleton.
The new skeleton?
The new one, yes.
All right, thank you very much. That's very helpful, thank you.
And so paragraph, ground 3 is the appropriate adult, and this then fits in with the previous 2. What is the starting point? What is the role of the interpreter, or the need for an interpreter? And then on the basis of that, what is the need for a minded to appropriate adult? And the judge said that it could have compensated for the lack of an interpreter by intervening, but in my submission, intervening in that way would have been an inappropriate thing for an appropriate adult to do. It's kind of begs the question as well, if you're an adult, you don't need an appropriate adult in the interview. So it's again a bit of a circular reasoning, and where the social workers had already decided that they were quite satisfied on the basis of his appearance and demeanour that he was an adult. Fairness does not require an appropriate adult any more than it did in HAM, where it was also decided that no appropriate adult was needed, or KA, which is the Andrews case that I cited to you.
Oh, so did Mr. Justice Swift decide in HAM that on the facts of that case an appropriate adult wasn't necessary?
Wasn't necessary, yes.
Right.
So, are you saying that the council, if these social workers had met SB and determined that he was not clearly over 25, then the appropriate adult process might be set in train then, because clearly they didn't set it in train before they met him.
If they thought he was in the grey area, then we would have had to move on to a more extensive process. And at that stage, fairness might have required that we get an appropriate adult.
Okay, so that would have involved halting whatever was going on effectively.
Yes. And probably, almost certainly in fact, at that stage taking him into care as a child, giving him the benefit of the doubt at that stage, if he was within the grey area.
So if in the course of the discussion that the social workers were having with him, they'd had doubts, I mean, they'd begun to think, is he really following what we're saying? Is he understanding questions and so on and so forth? And actually, we're not sure that he looks over 25. They would then have had to rethink.
Yes, they would have had to answer the questions that they asked themselves differently.
Yeah.
Because I've taken you to the bits of the assessment where they are clearly posing that question, are we sure? Are we sure? And at every stage, they say, yes, we're sure. And my lady, social workers must be able to do that. That's part of what is a Merton compliant process. Because the outcome is placing people who are clearly and obviously adults with children, vulnerable children.
Well, so there are bad outcomes if you get it wrong in either direction. Either you're placing children with adults, which is inappropriate, or you're placing adults with children.
Yes.
So it's a difficult decision.
It is,
yeah.
And social workers are extremely alert to that, and they're on the side of caution.
Sure.
But they are protective of the children already in their care, as well as children who might want to be in their care and want to get these decisions right. They don't want to be judicial review. So are on the side of caution more often than not.
Right, so that's the interpreter and the appropriate adults. Anything more you'd like to say about either of those two issues?
I think that's all I wanted to say on those, unless there's anything further on it. My ground 5 is a quite discrete issue, which is about what to do in these circumstances.
Do you want to say anything about the minded to process, because that's a separate ground on which the judge
Well, it's
found this was
all
unfair?
part and parcel of what is required for fairness.
Right.
And whether the credibility points had the importance that this judge thought that they did, against that background of, we say we're absolutely clear. He said, we thought perhaps. And so the judge erred in thinking that a minded to process was an important part of the process, when it wasn't credibility that was key to the decision. He took out everything that we'd obtained from SB in the course of chatting to him about his Facebook pages and so on. We would still have a basis for the decision that he was clearly and obviously over 25. We took out everything other than appearance and demeanour. There's a Merton compliant decision there.
So you're saying the decision would have been the same because the primary focus of the decision was what he looked like and how he behaved in the course of the interview.
And we should trust social workers to make those decisions.
So if there's perhaps one big message from your submissions, it is one shouldn't second guess the expert social workers in the field like this without very good reason.
Absolutely. Round 5 raises a discrete issue, which is the consequences of the decision to quash the assessment. And it's all about the material that's gathered, and in particular the fact that I mentioned earlier. The younger you get someone, the easier it is to make an assessment. After this decision was quashed, SB contended that no other local authority could look at it. However, in my submission that was wrong, and a local authority's evidence gathering, including the evidence of views of the social workers, should be preserved and used in future procedures as well.
Well, so is your point? This is a historical document. It records what he said to people and what they thought on a particular date.
The joint working guidance makes it clear that records should be retained, because it's not just about whether he's a child, it's about whether he's a child in need. It's a social work exercise that has more than one purpose.
And it's, I'm so sorry to interrupt, is a consequence of the quashing of the assessment that it's, I mean, what is the consequence? Sorry, what is the consequence of quashing?
That is one of the questions that I'm coming to this court for guidance on. What is the consequences of, what is the consequence of being quashed? As far as, I mean, this is why it's academic as far as my learned friend submits, because SB is not at present, as I say, returning to RBKC to ask for assistance. If it had been his view that he wanted to stay with RBKC, a further assessment would have been needed to see whether he was a child at that stage and in need of children's services. So would the assessors who were then dealing with him from RBKC be expected to go in blind with a clean start? For example, one key factor was that when the assessors asked SB how old is he checked his phone, looked at his date on the phone, and that is not somebody who knows their date of birth. That then is very important evidence that should then be preserved and carried forward into future assessments. The guidance says...
Where does it say that in the assessment? Maybe I haven't read it carefully enough.
It's in the witness statements, I think.
Oh right, so it's not in the assessment.
It is important as well that the impact on a person of having the same questions asked over and over again should be taken into consideration. That's in their favour as well, because we're talking often about young people who come through traumatic experiences. The Royal College of all the medical professionals are against people having, for example, wrist x-rays, because that's an intrusive medical procedure that's not medically warranted. But the outcome is that if you're in that grey area, you have to go through a whole process of interviewing somebody, interrogating them about what might be extremely traumatic experiences, their childhood, their reasons for leaving their country, their voyage here, which could involve trafficking and abuse of all sorts, and it can be extremely re-traumatising and can therefore prevent a young person really presenting the best coherent evidence of themselves. The best chance is going to be a first interview, and it would prejudice them to go through the same questions all over again without the next set of assessors knowing that that's happened. It's not in their best interests for that to be erased from history. It's re-traumatising sometimes, and that can affect their credibility. The other aspect, of course, is that you also get, in this case, for example, a witness statement reduced to writing, and that tends to, this court has often explored the effect of having a witness statement, which then becomes your record of what you remember rather than what you actually remember, and you're remembering what your witness statement says rather than what you really remember. So you've got to take all those sorts of considerations into question as well. So taking into consideration the guidance, that means that we preserve records. In my submission, the judge should have permitted this assessment to remain on the record and not prevented Southampton from having regard to it. In AB and Kent, Mrs. Justice Thornton said she wasn't going to quash the assessment for that reason. Kent then went off, and in fact we got independent age assessors to do a further assessment, which came to the same conclusion. And that was then judicially reviewed, went to the tribunal, and...
so which paragraph of Mrs. Justice Thornton's judgment is that, please?
Sorry?
Well, does she do... I'm so sorry. Does Mrs. Justice Thornton deal in her AB and Kent judgment with remedy or not?
She does mention it at the end.
Because you just told us that that's why she didn't quash the assessment. So if there's a reference in her judgment, I mean, we don't need to look at it now, but if you could just give us the relevant paragraph, please, that would be very helpful.
Yes, it's just the last paragraph at 58. Mr. Rule submitted that the existing assessment should be quashed given its flaws. Ms. Rowland submitted that the court should be pragmatic and recognise that it exists and provides relevant material for the assessment process to build on. Providing the limitations of the assessment set out in this judgment are recognised, I accept it provides relevant material for the defendant to build upon. Accordingly, I decline to quash the assessment.
Right, that's helpful, thank you.
And when we got to the tribunal, it was part of the material that the tribunal looked at.
And can you just remind us how Mr. Justice Bennathan dealt with this issue, please?
Well, he didn't really. Paragraph 41 notes that I sought to persuade him to reverse the decision to quash, and I was reproved for making an application which I shouldn't have made.
And you were given permission to appeal on this point on the basis that, frankly, the judge appears really to have misunderstood what you were trying to do.
Yes, I had made submissions in the course of the hearing that he should adopt the course adopted by Mrs. Justice Thornton.
Yes.
And he'd ignored that and hadn't told me why. And in my submission, he was wrong to quash the assessment for the reasons given again by Mrs. Justice Thornton.
So did the judge hear submissions about relief at the hearing?
I did make submissions as to relief at the hearing. I could see which way the wind was blowing.
Okay. Did you draw his attention to paragraph 58 of the judgment in the Kent case?
I believe I did.
Yeah. Okay. So let me just get over. So submissions relief at hearing.
I can't be 100% sure that I specifically referred to that paragraph, but I made the submission that it's material.
Yeah.
That any future assessors need to know about.
Yes. And part of the problem is what one actually means by quash in this context, which I think is, you were saying guidance on that might be helpful, and indeed
yes.
I'm really puzzling about it myself, but it's, I mean, in most of the administrative law contexts, the starting point is that something is quashed, it's treated as never having happened at all. And that gives rise to all sorts of problems, which are discussed in the textbooks. But that's not really the kind of situation we have here, is it? Where we're dealing with an issue of precedent fact, where a decision has been reached, and it's quashed in the sense that obviously it can't be relied on any longer in this particular case. But does that really mean it becomes, so to speak, like becoming a non-person or a non-event, or something rather short of that? I would have thought might be arguable.
I suppose it seems to have been assumed by Mrs. Justice Thornton that the consequence of quashing the assessment in that case would have been that nobody could keep a record of it. Because the passage you've just shown us suggests that's
it seems
the
to be
premise
premised
of
on
the
it,
discussion.
exactly, yeah.
And we had a similar case in Emma Waltham Forest. That was a case where the young person claimed to be 13, had wisdom teeth, and we thought...
Wisdom teeth at 13? Sorry.
My lady, I wish I'd had you on the permission.
I think most dentists would express astonishment at the idea you'd have erupted wisdom teeth at the age of 13.
Yes.
Anyway, sorry.
He subsequently admitted that he was 19.
Right.
But the local authority in that case did do an interview with him, two sets of interviews with him, if I recall rightly, and then didn't do a mind at two process. And those instructing me on that one agreed to reopen the assessment to basically do a mind at two process.
Yeah.
And again, it was Mr. Rule asked that be expunged from the record and that it be as if it had never happened.
Sorry, but he asked that what be expunged from the record.
The whole assessment process.
The whole
the
assessment
interview,
process.
the social worker's views of him, his answers. But of course, credibility and consistency are part of the assessment. And again, I haven't given you this judgment, in fact, and I should probably shut up about it. But
well, sorry, is there any discussion in the judgment of this point? That's what's interesting for us.
No.
No. All right. Well, then I think we're not so interested. To be brutal. All right.
Well, in Em and Wolf and Forest, sorry, there is a discussion of whether it should be expunged from the record, and it wasn't expunged. It's it was something that we carried on working on.
So that was discussed in the judgment.
In that one, sorry, I thought you meant in this judgment.
No. I'm so sorry. I didn't make myself clear. I was asking you whether there is any discussion in the judgment in this other case involving Wolf and Forest of the question that we're talking about now.
Yes, to some extent, yes.
Right. Well, could you just give us the reference to it, please?
So it's the Queen on the application of M and London Borough Wolf and Forest, 2021, EWHC 2241 admin.
Thank you very much.
And that was referred to by both me and Ms. Pasnier below in her skeleton argument.
Okay, that's very helpful. Thank you.
So, my lady, in my submission, this case shows the pitfalls that can arise when the facts are ignored, and it is important for both sides that facts are carefully recorded and carefully maintained a record of throughout, and that they are used to build up as complete a picture as possible. As necessary to meet the facts, the fairness in each case.
Yeah, okay.
And in this case, the facts were this was a man who looked very, very clearly over 18.
Yes,
So-
although that didn't persuade Southampton. Anyway, that's legally irrelevant.
And that should have been passed on to Southampton when they carried out their assessment.
So I see from the judgment that Mr. Justice Bennathan records that he wasn't asked to make a decision on the merits, i.e. to revisit the decision about SB's age.
Now, I think he was. I read it as saying that he wasn't asked to decide how old.
Yeah, well, that's what I mean.
Yeah.
So he just wasn't asked. It just seems curious that on the basis of A and Croydon, one of the court's roles is to decide what the person's age is as a question of fact, and you have a hearing, and judge doesn't deal with it and isn't asked to. Is that common? Because my experience, but it's a bit old now, is that when permission to apply for judicial review is granted in these age assessments cases, they're nearly always transferred to the upper tribunal for a fact-finding hearing.
That's right. Yes, when you grant permission on the FZ.
So why didn't that happen here?
It's one of the areas of that lacks clarity. I treated this initially as a request to reopen the decision as to his
No,
age.
I know, we've seen the debate in the judgment.
And the guidance tells you when you should do that. If there's some new material that makes a significant difference to your original finding, you should be alert to reopen it. For example, if the
I follow all of that, but the judge resolved that issue against you.
Yeah.
He said that's not what the judicial review was about.
So compare that one with AB and Kent. This is Justice Thornton, and in that case, the question was, what do you do next to Kent? Then start a new assessment, starting from scratch.
Yeah.
And in fact, Kent did a further assessment, got independent assessors to do it, and it was agreed that we should then do a full Merton assessment. Having done a short form assessment, we would do a full Merton compliant assessment at that stage, a full panoply assessment.
Right.
So there are various routes that the court can take. There's a lack of structure because this is a strange kind of judicial review.
Yeah.
There's a lack of any clear scheme as to what a court should order in these cases.
Yeah.
Whether it should be ordering a local authority to do a new assessment.
It would seem to me a bit pointless to to allow a fairness challenge if you haven't also dealt with the underlying merits which you've got power to do, because the fairness challenge may turn out to be to lack teeth, as it were, if the court's view on the facts is that the person is in any event an adult. It just seems to me that it's procedurally cumbersome, and it ends up with the possibility of two sets of proceedings. It doesn't
Yes,
seem
I agree.
desirable.
There is a lack of clarity in how the court should deal with these matters. It is right to say that in most cases, FZ and Croydon sets a low threshold for when someone advances a positive case that could go to a tribunal.
Well, that's the threshold for granting permission to apply for judicial review.
Yes, in terms of the grey area, really, where people are possibly 18, possibly 23, that kind of.
Yes.
So then the court has to do the full fact-finding process, which is extremely.
But why couldn't, in this case, the court have been invited to find what age SB was? That's what I'm not really understanding at the moment. Because it's so obviously, if the social workers are so obviously wrong, which must be his case, well, why didn't he invite the court? Well, I suppose it's not really a question for you. I'm thinking loud. All right, let's stop that.
In my submission on the evidence that was before the court on the last occasion, the only possible decision that would have been open to the court.
Well, that's that's your submission. On the evidence, that was the only possible. All right.
And that really underlines the question that I now ask, which is what order should this court make if you allow this appeal and set aside the judgment? Then the assessment by Kensington and Chelsea stand, as far as Kensington and Chelsea are concerned.
Yes.
Obviously Southampton have reached a different conclusion.
Sure.
That stands as well.
Yeah.
So it is a person then who has two ages as far as local authorities are concerned.
Which is
that doesn't really matter because only one local authority is being asked to provide them with services at the moment.
Right.
The Secretary of State might have a third view as to age.
Yes. All right. So does that cover everything you wanted to say?
I think it does, my lady, unless there's anything.
Do you want to check? Yes, do please.
This may be giving evidence, I suppose, but my clients asked me to point out that between November 2020 and March 2022, about 80 referrals came in from the contingency hotels where adults are placed.
Sorry, just say that again, please. You said it too quickly.
November 2020 to March 2022.
Yeah.
During the pandemic, of course. People were being placed in hotels in this area. 80 people were presented to Kensington and Chelsea claiming to be adults, and 50 of those were accommodated as children. Sorry,
claiming to be children.
Claiming to be children.
80 claiming to be children.
You said claiming to be adults. that's why my lady thought she had to check.
I think I probably said enough today.
Slip of the tongue. Okay, so that's just to give us some measure of the numbers involved. I mean, are the numbers more or less now that the pandemic's over? Or the same? Because this is relevant to the academic question.
Yes, there's been a huge drop-off, 8 since April 2022.
Oh, a huge drop.
That's only for this borough, isn't it?
In this borough.
It wouldn't necessarily
No, absolutely. Yeah.
I mean, as your ladyship knows, small boats are arriving on a daily basis. Not that people weren't arriving in other ways before. I don't know why there's a consensus in the politics about small boats. People are arriving all the time, one way or another.
And some of those people are claiming to be under 18. All right. That's very helpful. Is there anything else you'd like to ask? No. Okay, that's been very helpful. Thank you very much.
My lady, I can provide you with copies of my skeleton argument over lunchtime. Would that assist?
Well, I think we'll be able to get hold of them ourselves, probably. I mean, listen, would it be easier for you?
Well, frankly, I would find it very
Yes,
helpful
it'd
to
be.
have a hard copy.
Yeah, all right. What about you?
Since
Yes?
I'm-
All right. Well, yes, please. If you're going to provide two, you might as well provide three, please. Thank you very much. That's really helpful. Yes, Ms. Lou.
Yes, my ladies, my lord. If I just give you a minute to wait. As the court knows, we resist this appeal, and our primary position is that the appeal is academic and there are no good reasons in the public interest to hear the appeal. But in any event, in our respectful submission, there was no error of law in the judge's decision, and we respectfully submit that the judge was right to find the assessment to be unlawful for being, quote, clearly unfair for the combination of reasons. And it's our submission, and I will develop in due course, that he was careful in his age dispute in not taking a technical approach, and he looked at the evidence that was put before him and made the decision on the facts and circumstances of the case. The thematic principle in the case law that my learned friend doesn't dispute is that fairness depends on the circumstances.
Yes.
And we say that...
Well, that seems to be common ground.
And that seems to be common ground.
Because that goes back to duty, doesn't it?
That's quite
Yeah.
right. And we say, when I take you through the judgment, that he did that. And he did that carefully, cautiously, and arrived at the right decision.
So the difference between you is that you say he applied the legal approach which he described, and Ms. Rowland said, no, he didn't.
Yes, and I will take you to some of the documents that were before him that you weren't taken to, because I think that would shed a light on the references in his judgment to the social worker's notes, for example, and the issues of dispute and inconsistencies that caused him concern and was carefully outlined in his judgment. I'm mindful of the time, so I thought I would firstly just develop the academic point
Sure.
as a first point.
Well, you take your own course, but that sounds like a sensible approach.
So just as a context, when this judgment was handed down, it was handed down on the 17th of February 2022. One aspect that perhaps your ladyship and your lordship didn't pick up was the judge only made a quashing order and didn't make any other orders expressly because he didn't want to bind the appellant to take any further action. At that point, factually, the respondent was already in Southampton and had originally approached Southampton, but that they weren't party to the proceedings by the time of the hearing. And if I could just ask you to pick up the judgment at paragraph 40, and that's core bundle at page 106.
Sorry, I'm not sure I quite understood what you said, Miss Lowe. I think it's my fault. You said the judge didn't want to bind the appellant to take any further action.
Yes, so if I could ask you to, it would become clear, I hope.
What, by that you mean didn't remit it to the appellant in order to make a further decision?
Yes, so one of the aspects of relief that was originally sought in the grounds of judicial review
was a remittal.
assessment.
Yes, okay.
But the court decided not to grant that relief, and the judge said at page 106 of the core bundle, paragraph 40.
Yeah.
If I could just ask you to turn that
Sure.
up, the last 4 lines, ladies. It says, allow the application and quash the decision taken by the defendant. It will be for the local authority where the claimant now resides to fulfil their obligation to conduct a fair assessment process. And I do not think it necessary to make any further orders for that to occur, trusting as I do that whichever it is the relevant authority will carry out their important duty.
Well, he wouldn't have had power to order Southampton, would he? Because they
Pardon?
weren't. He wouldn't have had power to order Southampton to do anything because they weren't party to the proceedings. Were they?
No, but the point is he didn't direct any reassessment by the relevant local authority that had carried out the original assessment. So in an ordinary case, where a quashing is done, normally there is also a request for a reassessment in a
Sure.
case where there's no.
Yeah.
Well, I understand that, but on the facts, that would have been a ridiculous thing to order because he was somewhere else.
Well, and I would respectfully say it's a sensible thing
Yeah.
not to have done that.
Sure.
But the point is more a point in the context of the academic issue is that once this judgment was concluded, the relationship between the appellant and the respondent essentially came to an end because the appellant is not asked to exercise Children Act duties, is not asked to take him into care, and is not asked to do anything further to him.
Yeah, well, I think we've got that point.
And the point, and just to clarify the legal position that my learned friend made about, well, he could always turn up later and ask for support. Well, being a former relevant child is dependent on you having been in the care of the local authority for at least 13 weeks. That's paragraph 19B of Schedule 2 of the Children Act.
Sorry, just slow down, please. Paragraph 19B.
19 capital B,
Yeah.
Schedule 2
Schedule
of the
2.
Children Act 1989
Okay.
requires a child to have been in the care of the local authority for
So
at
your
least-
point is he wasn't in their care, so
Yes.
he's not entitled to services as a full.
Right,
got
and
that.
there is a judgment of this court in a case concerning age assessment. Well, what if the assessors get it wrong, but he had never been in care for 13 weeks? Could
Yeah.
it be that because they got it wrong, there's some sort of restitutional type principle that they would have had to treat him?
Didn't that point go to the House Rules or the Supreme Court?
No, it was a point that went to the court. It was a point at the Court of Appeal, a case called GE Eritrea.
Okay, GE Eritrea.
And it's 2015 PTSR, so it's I don't have the EWCA reference, but it's a 2015 case. I'll get you the citation over lunch, but
Yeah.
it's a case where even in a case where that particular local authority got it wrong, it's not a foregone conclusion that if the person was actually a child, they could just simply represent and say, you owe me duties. But this is a completely different situation where the responsible authority is Southampton. They've assumed the responsibility.
No, I understand that.
And
I
there's
had a
no-
feeling there was a decision of. There was a judgment of Baroness Hale on a similar point about someone who had been wrongly assessed not to
I
be a
think
child.
Your ladyship might be thinking about M and Hammersmith and Fulham
Maybe.
in 2018. That's a House of Lords authority
Yeah.
to do with whether a child knocked on the wrong door, so knocked on the door of the housing authority instead
Right.
of the children authority.
Okay.
And ought to have been housed by children's authority, which has consequences. That
Right.
if you are housed by the housing authority, you don't.
Yeah.
So I think that is the case that you're thinking
It may
of.
well
Then
be.
there's a
That's
consequential case called G and Southwark in 2009 that also said the same thing. So
All right.
M
That's
was
helpful.
2008 and G was 2009.
Dealing with a different point.
Dealing with a different point.
Okay,
But
thank you.
GE is bang on point in relation to age assessments and what happens when a local authority gets it wrong. Does that mean you go back in time and say, well, I would have and should have been accommodated, and therefore you owe me all these duties
Yeah.
because you should treat me as would have, should have accrued all
Right.
the time.
And GE Eritrea decides no, you don't
Well, no,
have
you
to, or you mustn't, or you might have
You
to.
don't have to. It's a matter of discretion. But that was a case. It's a matter of the local authority discretion. But
Right.
that was a case where the young person, it was a young woman, only had one authority to contend with.
Yeah.
It's a very different situation where you've got Southampton accepting the Children Act duties, and there are no transfer provisions of transferring responsibility under the Children Act after you turn 18. So there is a very discrete transfer provision under Section 20, subsection 2, when the child is accommodated by one authority, but another authority, but wants to transfer it to another authority.
Right.
So it's a very particular legal framework and done so that there's complete transparency about legal duties towards care leavers and looked after children because they are a vulnerable group of children. So I just wanted to, because of time, I just wanted to clarify that point so that we can start on the right footing as to whether he could just turn up at Kensington and Chelsea and say, hello,
Yes.
you've got it wrong.
So the bottom line is they would have a discretion to provide him with those services, but wouldn't be bound to.
Well, and their discretion would have been, well, you are Southampton's child. It doesn't prevent him from going to London and looking for housing there as an adult. Southampton will still retain the legal responsibility for him until he's 25. And as for housing, local authorities oftentimes have schemes for care leavers generally, and also for swapping between local authorities because people move around. None of that obviously is an issue in this case, other than if it's relied on by my learned friend to say, well, there are still wider implications and concerns in relation to even this particular respondent and or other people like him.
Well, I think she was suggesting that.
Yes. So, which is why I wanted to clarify.
Right. So you're saying that the argument you've just developed applies to housing as well. Is that right? Okay, that's helpful. Thank you.
I was going to then go on to develop properly my point about academic claims, but I'm mindful of the time.
Yes. All right. Well, let's rise. I can't quite see the clock. Is it about 1 o'clock? Yeah. All right.
Yes.
Shall we come back at 2 o'clock then, please?
I'm great.
And are we? Are you reasonably confident we'll finish if we come back at 2 o'clock?
Yes, when we discussed the appeal timetable, we
Yes.
thought that it was going to be 2.5 hours for my learned friend and hopefully under 2 hours for me because
Right.
my learned friend has covered quite a lot of ground. I
Yes.
will pick up a couple of things
Yeah.
from the same judgments, but won't take you extensively through some of the
All right. That's really helpful. All right. Well, thank you both very much. All I can say is thank everybody.
Court rise.
Council and solicitors and others.
Court rise.
You've got all the bundles that were delivered by courier yesterday now, I think.
Oh, I haven't got a clock, so you want me to?
Rose?
Yeah.
Yeah, I think, because if you've got those, my skeleton's in those and I don't need to go and get copies, so.
Okay, I'll ask her now.
Thank you very much. Yes, they're quite good. Next we go out, though, we'll lose. Big laptops, they're probably safe. I'll just